What's up YouTube? It's Nick from Things Money. So today I'm going to follow up from the video yesterday about the Eidl grant and loan that we received for my small business. This video is going to cover all of the terms and conditions and fine print located in the loan agreement. So I will post the actual loan agreement somewhere here, and you can follow along with me as I talk about it. So document starts out, U.S. Small Business Administration Loan Authorization and Agreement. So this is different than the actual promissory note that you will also sign. The promissory note is the promise to pay the money back with the terms and conditions and payments and things like this. This agreement is stating all of the things you're agreeing to by taking this money. There's been a lot of videos on YouTube that I've seen that have they've talked about this, kind of went a little bit in depth, but I'm going to give my point of view and my opinion coming from someone that's been on both sides of these loan agreements. All right, so first topic, payment. Installment payments, including principal and interest, $122 monthly, beginning 12 months from the date of the promissory note. The balance of the principal and interest will be payable 30 years from the date of the promissory note. Interest will accrue at a rate of 3.75% per annum and will accrue only on funds actually advanced from the date of each advance. So if your advance was $25,000 today and $25,000 6 months from now, you would only pay 3.75%, actually be half of 3.75% on the other $25,000 at that time. Payment terms. Each payment will be applied first to interest accrued to the date of receipt of each payment, and then the balance, if any, will be applied to the principal. So basically your first portion of your payment will all be interest, and then the rest will go to principal, kind of like a house mortgage. Each payment will be made when due, even if at that time the full amount of the loan has not been advanced or authorized amount of the loan has been reduced. So if you were authorized $100,000, only received $25,000, and then it took the rest of the time to get the rest of the money you were owed, your payment would be on the full amount, the $100,000 that you were, the loan you were given. That gets kind of tricky. I've only heard of a handful of people that have gotten incremental portions of the loan. Most people have gotten the full amount up front or at least over a few days. All right, here's the big one, collateral. For loan amounts of greater than $25,000, borrower grants the SBA a secured party hereunder a continuing security interest in and to any and all collateral as described hereon the source of payment, to secure payment. So basically, if you default on this loan, they're going to take the collateral to pay off the debt, and they'll sell all your business assets to be able to pay off the debt. This is pretty standard in any bank transaction. There's always, if they don't do, let's say, a vehicle or a property, they will file a UCC on all business assets, which is a uniform commercial code, basically listing any and all assets that the company has. Such as some examples I'll throw: equipment, instruments, including promissory notes, which would be if your company lent money to another company or an individual and they owed you money, now that money goes directly to the SBA if you default. Accounts, including healthcare insurance receivables and credit card receivables. So if you are a business that takes in credit cards or gets paid by merchant services, swipe credit cards, and you get those deposited every day or every couple of days, once you default or once the SBA has claim to those funds coming in. And there's a couple other ones in here. You can see them on the list. But for loan amounts of $25,000 or less, the SBA is not taking security interest in any collateral. So my business, we did $24,900. So I signed no UCCs. They don't have anything on business assets. I can function as normal. Now here's, if you had collateral, requirements to relieve collateral. Borrower will not sell or transfer any collateral except normal inventory turnover in the ordinary course of business described in the collateral paragraph hereof without the proper written consent of SBA. I know doing other SBA loans in the past that if the collateral is substantial, so let's say a $50,000 vehicle, we would have to go to the SBA to get authorization to sell that equipment. I have never had to go to the SBA for, let's say, a photography business sold one camera and wanted to buy another camera. We never had to go to the SBA to have them give that customer permission to sell that camera. That's kind of in the normal course of business, is the equipment they use and transact out. Borrower will not directly or indirectly use portion of the proceeds to relocate. That's basically because the disaster loans are dedicated areas. Let's say your dedicated area is Columbus, Ohio. You can't pick up and move to Trenton, New Jersey, let's just say, because your impacted area was why you got the loan in the first place. Or if you do have to relocate, you have to seek permission from the SBA. There's a couple other ones in here about returning documents, compensations. I know this loan agreement is kind of a boilerplate, and I don't think it was specifically meant for this situation we're in, because a lot of people have gotten the double, the PPP and the EIDL, and I will go into the PPP program in another video. But it's basically saying if you receive any other grants or loans from any government organizations, it would have to pay this one off. There hasn't been clarity on that one as far as from Congress or anything saying yes, you need to pay that off. They're actually for two different things. The EIDL was for working capital and the PPP was for payroll. You can kind of use them together. So if your 8 weeks of the PPP ran out and you needed to continue paying employees, you could use the EIDL if you had to, but they're not to be intermixed. Hazard insurance is if your loan is greater than $25,000, they're going to require that you have hazard insurance on your place of business. Books and records. And this is pretty standard for any kind of lender, any kind of loan. They are basically saying they have the right to come in and look at your books at any point and any time. 99% of the time, unless your relationship or your loans are huge, the lenders or the SBA is not going to ask for financial statements. So what they're saying is you have to maintain proper record and books and accounts for 5 years, the most recent 5 years until 3 years after the date of maturity, including extensions or the date the loan is paid in full. 30-year term, you would have to keep your records for 33 years or 3 years after the maturity. Now, if you pay it off in 5 years, keep the record for 7 years. And it's basically any kind of financial statements, operating statements, insurance policies, tax returns, dividends paid, and records of compensation to officers, directors, holders of 10% or more. They just want to make sure you use the money for the right purpose. And then they're saying if basically you're authorizing the SBA to collect that at your expense. So if they ask you to mail in all your copies of tax returns, you have to copy them and mail them in. It also says borrower will furnish to the SBA no later than 3 months following the expiration of borrower's fiscal year and in such form as SBA may require borrower's financial statements. So they're basically saying you have to supply those if asked. And then upon written request, the SBA borrower will accompany such statements with an accountant's review report prepared by an independent public accountant at borrower's expense. That gets more into higher levels of lending. If the original was the $2 million, I've never seen audited financial statements for companies under $10 million. So, because it is expensive to get an accountant to actually go through all your books and verify every receipt, transaction, things like that. And it says you authorize all federal, state, municipal authorities to furnish reports of examination records and other information relating to the condition and affairs of the borrower. So basically, that your business exists, you don't have any judgments or liens against your business, and if it does, they have to let the SBA know. Limit on distribution of assets is basically saying you can't give preferential treatment, make any advance directly or indirectly by a loan, gift, bonus, or otherwise to any owner or partner of its employees. So you can't take this $25,000 from the business, give myself as an officer a loan for $25,000 at 3.25% or 3.75% for 30 years and basically get the interest paid for it that way. It would be a pass-through. That would be a pass-through loan. And then it includes equal opportunity requirement. You're supposed to hang these visually clear posters in your business, which most businesses have that, I guess, unless you're a home-based business without employee traffic. But even my home-based business with 3 drivers, I have my equal opportunity posters in my garage on my refrigerator, and also the labor law posters and things like that. And then there's a bunch of certifications. You're saying that there's been no substantial adverse change. You didn't go out of business prior to getting this money. Yeah, judgment liens, tax liens, mechanics liens, bankruptcy, financial reverses, arrest or conviction or felonies. It's saying you did not pay. No fees have been paid directly or indirectly to representative for services provided or to be provided in connection with applying for the closing of the loan other than as reported. So if you had a third party help you apply for this loan and you paid them, but you would have to disclose that on a different form. In fact, it was one of the check boxes that asks if you paid someone to help you do the loan. You're not 60 days past due on any child support. That's a standard. Every time I've done an SBA loan, or any loan, they have to make sure you're not 60 days past due on child support. And more fees, and then it says the borrower certifies to the best of his or her knowledge and belief that the certifications and representatives in the attached certification regarding lobbying are true and correct and complete and are offered to induce SBA to make the loan. So you didn't have a friend of congressman who passed this loan knowing you were going to get the money, or some weird off-reaching thing like that. Basically, if you violate the loan agreement, you have to pay back immediately and payable. SBA's failure to exercise its rights under the paragraph would not constitute a waiver. So if they didn't come after you, it's not going to say they can't. A default or any violation of the terms and conditions. So basically, a default can pretty much be anything. If you've ever had a standard commercial loan, there's tons of things in there for default, death being one of them. I don't know how they would prosecute you for if you died, but that is one of the conditions of default. The largest one is if you stop paying. If you stop paying, you're going to be in default. Or if you stop paying other debts, it's called cross default. So if you default on one loan, you basically default on all of them, and that's so they can get in line to whoever gets paid first from your assets. Disbursements will be made to the discretion of the SBA counsel in accordance with the loan authorization and agreement and general requirements of the SBA. This is where it got hairy, to where they were dispersing certain amounts at certain times, and they're saying no disbursements will be made later than 6 months from the date of this loan authorization and agreement unless SBA in its sole discretion extends the disbursement period. And then parties affected, it's all binding. Board of Directors shall have 180 days receiving a disbursement of the loan, submit to certificate and resolution. That's if you're a C corporation with a Board of Directors. And then it is signed by James Rivera, who is the Associate Administrator, and then I signed it down here but redacted it. And that's pretty much the fine print. I know there's more that I could go into with the loan agreement, but I just wanted to kind of shed a light on a little bit of the things in the loan agreement. These are pretty much standard. Like I said, they're boilerplate. Each bank, credit union, whatever, will have a similar loan agreement with similar terms. It's just to basically protect the bank in an event that you default on the loan. Hope you found value in this video. If you did, I'd appreciate a like. If you'd like to learn more, over the next couple weeks, I'm going to try and put out more videos for the PPP, maybe more on the EIDL with a promissory note, other financial advice. So if that sounds like it'd be interesting to you, hit the subscribe button. I appreciate it. And thanks for following along on this financial journey. Have a great day.